Hello and welcome to the first ever Scopelitis Transportation Law video update. I'm Braden Core, a partner in our Indianapolis office, and I'm coming to you today with a preview of the oral argument in a trucking case pending before the U.S. Supreme Court. That oral argument will be heard next Wednesday in Washington, D.C. in a case called New Prime. We wanted to spend a few minutes today getting you up to speed on that case so you're ready for what may get discussed during next week's oral argument. Now, it's unusual to have a trucking case in front of the Supreme Court in any event, especially one that raises such important issues for our industry. There are two questions in particular that the court has decided it will hear. The first one relates to an arbitration issue, and it deals specifically with an exemption from the Federal Arbitration Act for transportation workers. What this means is that when a company tries to compel arbitration, to send a piece of litigation to arbitration instead of the courts, it is typically invoking a federal law called the FAA, enacted many years ago, that allows courts to do so. The problem for our industry is that there is a carve-out from that law for transportation workers. Now, the law is pretty well settled that a driver is a transportation worker. But the transportation worker also has to be under a contract of employment. You'd be forgiven for thinking that that would exclude owner-operators, so we don't have to worry about the exemption if we have owner-operators. Unfortunately, you would be wrong. In the opinion that the Supreme Court is going to review, which was issued by the First Circuit Court of Appeals, that court held that owner-operators are categorically exempt from the FAA. They have contracts of employment. That's one of the issues that the court plans to address. Now, there's an important caveat to this. Even if we're exempt under the FAA, there is still state law that we can use to compel arbitration depending on the agreement and the state law that applies. But the availability of the FAA is important for the industry. That issue is teed up for the court's review. Another issue related to the first one that the court will be hearing has to do with who gets to decide whether the exemption applies. Can the courts decide that question, or do the arbitrators have to decide that question, assuming the parties have agreed to have the arbitrator resolve those threshold issues? That's an important issue that goes beyond our industry. It's another one to be decided by the court. Now, all of this is somewhat in flux because of the pending confirmation of Judge Kavanaugh to the U.S. Supreme Court. We're recording this on Tuesday, September 25th, and right now the status of his nomination is in flux. This matters for the New Prime case. If there are only 8 justices on the Supreme Court when that case is heard and decided, we could end up with a 4-4 tie. That's significant because a tie decision leaves in place the lower court opinion. Remember, that's the decision that said owner-operators are exempt from the FAA. So, a lot to be decided here. We don't know if Judge Kavanaugh will be appointed to the Supreme Court. We don't know if he will be appointed in time to participate in this case. And it could affect the ultimate outcome. Next week, we will have Scopelitis attorneys in attendance at the oral argument. We will provide immediate reaction from the courthouse steps at the Supreme Court of Washington, D.C. shortly after. So watch this space. Watch social media for further updates in this regard. And if you have questions about any of this, feel free to reach out to the independent contractor team or the arbitration team here at Scopelitis. Our contact information is at the bottom of the email that sent you the link to this video. Thank you.